This is Barry Zalma speaking for Claim School Incorporated. Today I'd like to talk about damages available for breach of an insurance contract. Generally, the purpose of an award of damages for breach of contract is to compensate the injured party and provide the benefits promised by the contract. The general rule is that damages are meant to place the claimant in the same position as if the contract had been performed. In the 16th century, when our English forbears began resolving disputes through trial by jury rather than ordeal or battle, courts were divided into courts of law and courts of equity. The law courts dealt with money damages for various offenses like breach of contract, negligence, or intentional torts. In order to discourage people from breaching contracts, the law allows various remedies to the party to the contract who lost the benefit of the bargain. In the event a breach is proved, a court may award 1. Damages, 2. Specific performance, 3. Contract rescission, and/or 4. Contract modification or reformation. While the British common law was forming, damages were the province of the law courts, while the other 3 remedies were handled by the courts of equity. In the 16th century, the equity courts were handled by clerics who, it was thought, were better qualified than appointed law judges to provide the fairness required for equitable remedies, because equity by definition means fair. The damages allowed for breach of contract were limited to compensatory damages. These are damages for a monetary amount that is intended to compensate the non-breaching party for losses that result from the breach. The aim of compensatory damages is to make the injured party whole again, but not put the non-breaching party in a position better than contemplated by the contract terms. Damages for breach of contract were traditionally limited to the need to compensate the plaintiff for the harm proximately caused by the breach. Damages must have been contemplated by the parties or be reasonably foreseeable at the time the contract was entered into. Contract damages do not usually allow recovery for unanticipated harm or injury as do damages for injuries caused by torts. Damages for breach of contract must be clearly ascertainable. Proof of actual harm and its cause must be established. Damages restore the plaintiff to the position they would have had the contract been fulfilled. In other words, plaintiff is entitled to the benefit of the bargain. A plaintiff suing for breach of contract may not recover an amount greater than that they would have gained had the contract been fulfilled. Now, there are various types of damages. For example, compensatory damages are not meant to be punitive in nature. The goal is not to punish the breaching party for immoral conduct, but rather to put the non-breaching party back into the position he or she would have been in had the contract been performed. Then there are expectation damages. These are damages that are intended to cover what the injured party expected to receive from the contract. Calculations are usually straightforward as they are based on the contract itself or market values. Sometimes they will claim consequential damages. These are intended to reimburse the injured party for indirect damages other than contractual loss. For example, loss of business profits due to an undelivered machine. Consequential damages aim to address the flow of problems that reasonably result from a party's breach of contract. In order for the injured party to recover, the injuries must be a direct result of the breach and be reasonably foreseeable to both parties when they entered into the contract. Consequential damages are designed to compensate for secondary or derivative losses resulting from special circumstances particular to that contract or to the parties. On occasion, one would seek quantum meruit damages. A court can award one party payment for what they deserve for any work that he or she performed before the other party breached the contract. Translated from the Latin, the term means as much as he deserved. In California, there is also statutory measures of contract damages. For example, in very limited circumstances, statutory law specifies the measure of damages. These circumstances usually are 1. An obligation to pay money only, 2. Covenant of season, the possession of land or chattels, of right to convey, of warranty, or of quiet enjoyment in a grant of real property, 3. A covenant against encumbrances, 4. A contract to convey land, 5. Agreement to deliver quitclaim deeds, 6. Agreement to purchase real property, 7. Leases of real or personal property, 8. Obligations of carriers of passengers, freight, and messages, 9. Warranty of an agent's authority, or 10. Other statutory schemes governing the transaction. Traditionally, breach of an insurance contract only allowed damages that were those specified above from law courts who could determine the monetary loss caused by the breach. In addition, insurance contracts were subject to the courts of equity, who could formulate a fair remedy to a dispute over a breach of contract where money was not an appropriate remedy. Equitable remedies involve the court ordering the parties to act or to refrain from acting. Many contracts also include a right to liquidated damages. These damages are damages that are specifically stated in the contract because it would be difficult for the parties to prove the exact amount of damages in a case of a breach. To protect the parties to the contract, they agree at the time of contracting what the damages will be in the event of breach. Now, when a contract is breached, there are also equitable remedies available, all from the same judge in the United States, where we don't break up courts of equity and courts of law into separate agencies where one judge can sit as a judge of equity and in the morning and in the afternoon sit as a law judge. In modern American jurisprudence, judges sit as both law judges and equity judges, and they can issue remedies like specific performance. Specific performance is usually available when the contract involves some kind of unique goods or other unusual benefit to the other party, and ordinary money damages are not sufficient to make the aggrieved party whole. Real estate is often the subject of specific performance because, in most cases, each piece of property is unique. The court of equity, being fair to both parties, will issue a judgment that requires the breaching party to perform its part of the bargain indicated in the contract. For example, if one party has paid a premium for fire insurance, but the insurer refuses to acknowledge the existence of the policy, the court of equity would require the insurer to recognize the existence of the policy and pay the benefits promised by the policy. In such a situation, the court of equity would leave to the parties the obligation to determine the dollar amount of the benefits available to the insured. A law court, sitting as a court of equity, can also deal with the equitable remedy of rescission. If the court determines that the contract of insurance was entered into as a result of deception or mistake, the contract which is the subject of the dispute can be rescinded, that is, canceled from its inception as if it never existed. This is a remedy typically given when both parties agree to cancel the contract, or if the contract was created through fraud, misrepresentation, or concealment of material fact, or mistake of material fact. For detail on the remedy of rescission, consider my book, Rescission 2nd Edition, which is available from Amazon.com as a paperback or as a Kindle book. There is also a different remedy called Reformation, which a court of equity can render. The contract of insurance is then rewritten by the court with the new contract reflecting the parties' true intent. Reformation of an insurance policy requires a valid contract to begin with and often is used when the parties had a mistaken understanding when forming the contract. The equitable remedy of reformation allows the contract of insurance to let each party receive the benefits of the contract they believe they made and fix errors in transcribing the understanding to the written contract. There are also limitations of damages by contracts of special circumstances. So when a contract is terminated according to its terms, damages are limited to those accrued prior to the termination. If the contract contains a provision allowing termination without cause upon due notice, but the party breaches by terminating without allowing the notice period to expire, then damages are limited to those that would potentially accrue during the period of the required notice. For instance, an insurance policy is improperly canceled before its expiration. Damages may result if the policy is not replaced and a loss occurs. When the breach of contract is partial, prospective damages are not available. Plaintiff may recover damages only from the time of non-performance to the time of trial. Damages may not be recovered for anticipated future performance. This video was adapted from my book, It's Time to Abolish the Tort of Bad Faith, and the next video will deal with that tort and the damages that flow from it. If you found this video interesting or useful to you and you watched it on rumble.com, please click on the Rumble button, and if you watched it on YouTube, please click on the like button. Thank you for your attention.